matter for inclusion in Lordship's list.
Hearing of second appeal.
My lord, my lord.
Yes, after 2 weeks.
Lord, application in connection with second appeal, Miller.
Yes.
My lord, may I be permitted to mention, my lord, I am for the appellant insurance company. Hearing matter. Paper book ready.
Yes, after 2 weeks.
May I
My lord,
permit-
may I have my lord's gracious leave, my lord, to mention a matter I am mentioning virtually, my lord.
Yes.
My lord, this is with regard to a inclusion of a contempt, my lord. Herein before we have mentioned this matter thrice. Inquiry in the department, my lord, still it is not been listed. That is the whole difficulty, my lord. We are suffering since long.
Appear for the first time. Is it to appear first time? Contempt application.
Yes, for the first time, my lord.
Wait, let us see. Give the slip.
May I permit?
My lord, we have, earlier, my lord, we have mentioned thrice, my lord. Kindly some precedence me given.
Let the records be traced out.
Inclusion in the list.
Very well, my lord. Grateful to your lordship.
Filed in 2024. Till date, it is not.
The substitution application. Yes, it will come under the category of application, provided the records are here. Yes, give it.
Chief, may I be permitted to mention?
Yes.
Review application in connection with the first miscellaneous appeal, Your Lordship.
Yes, give it.
I'm grateful.
File the claimant file the appeal. So for admission and notice of this and call for the record.
Application for what? Section 5.
No. 166 claim has been filed, my lord. On behalf
After 2 weeks.
notice has been same also.
Yes.
Mention for inclusion, my lord.
Inclusion of hearing.
Yes, ma'am.
Hearing of second appeal or claim case.
Second appeal.
Yes, after 2 weeks. Yes, call the list.
Respond.
Yes, all the appeal stands dismissed.
Deep level. My lord has not interfered with the quantum.
No.
Deep level.
Yes, hence this appeal FMS 717 of 2024 stands disposed. Judgment and award dated 13th February 2024 passed in MSC case number 48 of 2019 stands modified to the extent that the respondents' claimants are entitled to rupees 20 lakh from the Appellant National Insurance Company Limited. Appellant National Insurance Company Limited shall deposit rupees 20 lakh before the Registrar General, High Court, Calcutta, along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is already deposited, no further deposit be made. The respondent's claimants will be entitled to withdraw the compensation upon compliance of necessary formalities. Balance amount, if any, be returned to Appellant Insurance Company.
Judgment item number 5.
Second appeal.
Yes, hence this appeal FMA 855 of 2025 stands disposed. Judgment and award dated 17th February 2025 passed by learned Additional District Judge Fast Track Court Shuri Bidbhum in MSC case number 236 of 2019 stands modified to the extent that the claimant's respondents are entitled to rupees 40 lakh from the Appellant National Insurance Company Limited. The Appellant National Insurance Company Limited shall deposit rupees 40 lakh along with interest at the rate of rupees 6% per annum from date of filing claim case till today. In the event compensation awarded by learned trial court is already deposited, no further deposit be made. The claimant respondents are entitled to withdraw the compensation on compliance of necessary formalities. Balance amount with accrued interest be returned to the appellant.
আমরা দেবো মা Judgment item number 6.
For the applicant, my
কালকে দিলে আমি ফোন করে যাবো
Hence, this appeal FMS 629 of 2011 stands allowed. Judgment and award dated 21/5/2010 passed by learned additional district judge 9th Fast Track Court, Alipur in MSC case number 26 of 2009 is set aside. Appellant claimant is entitled to compensation of rupees 3 lakh from respondent insurance company. Respondent New India Assurance Company Limited shall deposit before Registrar General High Court Calcutta rupees 3 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. Such deposit shall be made within 8 weeks from the date of communication of this order. The appellant claimant will be entitled to withdraw the compensation upon compliance of necessary formalities. Deficit court fees, if any, be paid within 2 weeks.
Item number 8.
Maybe, Lordship, I'm from petitioner, Lordship.
Let me see the last order.
My lord, 8, item number 8 to 11.
Yes. So time was sought to
Yes,
comply the order.
my lord, the order has been complied, but we need time to file the affidavit.
Affidavit of
Complied.
Yes, record an order.
Lordship, regarding item number 11, we do not have any information right now.
Anyway, let him file the affidavit on the next day. Let us see.
Affidavit-
Learned advocates for the parties are present. It is submitted by learned advocate for the contemner respondents that in terms of earlier direction dated 12/6/2026, the state order has been complied. The order dated 3/10/2025 passed in WPA 23419 of 2025 is already complied. Stop. In the facts and circumstances, the contemner respondents are granted opportunity to file affidavit of compliance on 31.
Grant 2 weeks, my lord. 2 weeks hoche time rakho. 30.
31, it comes 1 week.
Kind another week.
7/8/2026 for filing affidavit of compliance. 8 to 11.
8 to 11.
Okay, 8 to 11, same order. এই WPA নাম্বারটা চেঞ্জ হবে।
আলাদা আলাদা করলে ভালো হয় না?
এটা WPA এটা তো অন্যটা WPA নাম্বারগুলো চেঞ্জ হয়। হ্যাঁ, অর্ডারটা এক হবে, খালি ফার্স্ট ইন WPA নাম্বার ওটা চেঞ্জ হবে।
12 and 13.
But 12, I'm for the petition, my lord. But the appeal was filed in the month of December, my lord, and that has been usually an excuse for not allowing me to participate in DME. My lord, the similar matters that
It's passed, let me see.
No,
8 and 9.
no, they are short time, my lord, because the appeal is pending.
No, in 12, they have been called for. On 28th, they have been called for medical.
But I have to take instruction because I have no such instruction. That in 12 they
Instruction.
Means
I'm keeping
signal
it
law,
Friday.
signal law. Well, we have a copy of the.
may I get the copy? My lord, if-
we
Well,
can grant
refer to your
you a-
submission that the order has been complied.
Not order. They have been called for.
DME.
We're taking steps for compliance because there is a medical which has to be done.
Yes.
On 28th, they have been
Item
called
12.
12 and 13 possibly. Okay.
But in that case, I request for the copy of the letter, my lord, because I do not.
In 13 copy has not been served.
Insofar as 12 is concerned, my lord, I.
আচ্ছা 12 টাকে করে নি 12 টাকে করে নি
Advocates for the parties are present.
12 টাকে করে নি
It is submitted by the learned advocate for the appellant, the contemner, that
ওটা করে নি
during pendency of the appeal, the writ petitioners were permitted, appeal is pending.
appeal is pending, yes.
During pendency of the
Without
appeal,
prejudice, we
the
have
writ petitioners were permitted to appear for medical
no,
examination.
they have been directed to appear on
No, the-
28
The writ petitioners are directed to appear in the medical examination
on 28th
on
July 28th July.
on 28/7/2026. In the facts and circumstances, the learned advocates are requested to file necessary report on 7/8/2026.
But may I request my learned senior friend to give me the copy of the communication letter that the
Learned advocate for the contemner respondent is requested to serve a copy of the letter directing the writ petitioner to appear in the medical examination to the learned advocate.
grateful, my lord.
13 এ কি আমরা আছি? You have not been assigned in 13. 13th we have not been appointed, my lord.
You are not.
Although
Let me
it is-
see the last order. You can do one thing. You can take instruction, provided somebody has not been appointed. Because in the writ petition you appeared.
In 13 also he has been called, but we have officially not been appointed.
The learned advocate for the petitioner is present. The affidavit of service showing the affidavit of service file be kept with the record. I'm recording your name.
Both of us.
Mr. Dash, who is appearing for the respondent authorities in other matters with regard to the self-same issue, is requested to appear in this matter and take necessary instructions. Let this matter appear on 7/8/2026.
কমপ্লায়েন্স রিপোর্ট দেবে ঠিক আছে আর এটা কখনো সাইন হয়নি আমরা একটু সার্ভিস করে এখন করে দিই গ্রেটফুল গ্রেটফুল
The legal none appears for the petitioner.
Contemner.
Do you have any instructions?
Yes, like just now I have received the.
Okay, none appears for the petitioner. Stop. However, learned advocate, Mrs. Namta diye deben, give your name. Appears for the contemner respondents and seeks time to take necessary instructions. In the facts and circumstances, the matter stands adjourned till 14/8/2026 for filing necessary report. আগেরটা 7 আছে, কিছু বোধহয় ইয়ে আছে, ওই সবই 7 আছে, যাক এটা ইয়ে 14 তারিখ।
Fixed matter, item number 7, 10:30 fixed matter.
Your Lordship, I'm appearing for the appellant. Lordship, this is appearing for correction, Your Lordship.
Item 7.
Yes, Your Lordship.
All correction. Yes, what is the correction?
Your Lordship, the title suit number has been wrongly written as 458 instead of 485.
No, in the judgment and order dated, which order judgment? 1/4/2026.
Yes, Your Lordship.
No, which order are you seeking correction?
Lordship, order number, order dated 1st April 2026. The last third line from the last, file in TS 458. It's supposed to be 485.
You have a copy of that order, please? Full order dated.
Order dated 1st April 2026.
1st April 2026.
Give what correction you are seeking?
পেজটা খুলে দে, পেজটা খুলে দে, পেজটা খুলে দে।
Have you indicated?
নামাই দাও।
Indicate.
ওইখানে এটা তো এইটা এইটা ফার্স্ট এটা ফার্স্ট 485.
Yes, learned advocate for the appellant. You are for? Both of you are for the appellant?
For the appellant.
Learned advocate for the appellant are present. The matter is put up for necessary rectification of order dated 1/4/2026. Stop. In the order dated 1/4/2026, instead of TS 458 of 1988 appearing in paragraph 2 of the said order, it should be rectified as TS 485 of 1988. Other contents of the order dated 1/4/2026 remain unaltered.
Lordship.
Item?
Item 28 for the respondent here.
Okay. No, actually today is not for application, but I just asked.
Original fact matter item number 1.
Item number 1, I appear for the plaintiff number 2 series. Now, in this matter, witness action was going on. The second witness in the suit has already deposed. Let a date be fixed, my lord, for the third witness to come and depose, my lord.
Third witness.
Third witness.
The third witness is the plaintiff.
Plaintiff 2 series. Anyone from the plaintiff number 2 series will come and depose. The plaintiff number first plaintiff who was appearing in person has already deposed in 2013. Thereafter, the second witness, a person from the registry office came. A person from the registry office came and deposed, my lord. Now the third witness from the plaintiff number 2 series will come and depose, my lord. The entire suit, my lord, is with regard to the interpretation of a document executed somewhat in 1905, my lord. What portion would be allotted to the parties and what?
How many plaintiffs are there?
There are 2 sets of plaintiff. Originally, it was a 1 set of plaintiff.
2 series.
Two sets.
Who you are representing?
The 2 series.
The question is, you see, as because this court is sitting only once a week, and there are other matters pending, and this witness should be done by commissioner. Otherwise, it will be very difficult to.
No, my lord. Only 1 day. I will complete in 1 day. Examination.
Very difficult, you see.
Any day, my lord.
See, only due to this paucity of time. Otherwise, we don't know. Because so many days this matter was adjourned.
Yes, absolutely.
So
My lord, let us first try in court, my lord. Let us first try.
To do it in by
I understand, my lord, but
Otherwise, you see,
all this North Cole person, my lord, hand-to-mouth condition, they will not be able to afford, my lord, with the teacher's of humility, my lord, they will not be able to afford the cost, my lord. But if we fix a date, let me bring my witness if it can be done in examination in the box. No? Kindly. Any day fix.
Shall I keep it on 1st of August?
Grateful.
This working day, 1st of August.
1st of August. Saturday.
Friday.
No, 1st of August is Saturday.
My lord, is not Saturday. 1st of August, if my then others say if there is a resolution, any resolution on that day, we keep it on in the normal days, my lord.
Normal days, you see, there are so many matters.
Any day at 12 o'clock, my lord. Any day at 12 o'clock.
Advocates for the parties are present.
Saturday হবে না? হবে না, এনারাই আছে।
As the evidence of plaintiff number 2 series is required to be adduced, the matter stands adjourned till 14/8/2026 at 2 p.m.
2 p.m. Grateful. For witness
of plaintiff number
2 series. Yes, 14th August, 2 p.m. Grateful, man.
Item number 2. Item number 2, 3, and 4, my lord. My notes are going. It is ready, my lord. List of dates and argument, my lord.
I'm for the intervener, Lordship.
I appear for the plaintiff, your lordship. The written notes are ready.
Yes, record and order. Learned advocates for the parties are present. The hearing of the matter was already concluded, and the parties are granted opportunity to file written notes of arguments, which the parties have filed today. Let this matter appear for judgment on 14/8/2026.
Lordship, let the interim order be extended.
The interim order granted earlier stands extended for a period of 8 weeks until further orders, whichever is earlier.
Deeply obliged, Lordship.
Number 5.
My lord, the item number 5 is
2, 3, 4 সব একসাথে।
My lord,
the item number 5 is my application for contempt, my lord.
My lord, I am yes.
The last order passed.
My lord, last order was passed on 2026. My lord, my learned friend's client, Reserve Bank of India, filed a report before your lordship on 19th of June.
My lord, yesterday we were served with a copy of the
Your
exception.
lordship was pleased to give me liberty, my lord, to file the exception to the report by way of an affidavit. My lord, I have service. I am filing the affidavit, my lord. My opposition copy is already served yesterday.
Yesterday I have received. My lord,
If my learned friend wants to file any reply, my lord, kindly extend
Perhaps
the
it would not be required because he has admitted the position as I had explained on the earlier occasion. Because where lies the predicament so far as Reserve Bank of India is concerned in complying with your lordship's order? The coordinate bench has passed an order, just to refresh your lordship's memory, my lord.
Yes, I have recorded
Yes,
that.
so that was recorded in the previous order. And what I find from the exception that has now come on board, your lordship will kindly turn to page number 30. That's in the execution proceeding GA4, which has been filed, I believe, by my learned friend who is appearing for the petitioner. Kindly see what reliefs they have sought for in the master summons, page number 31. এখন যেটা দিলেন ওটা দিন।
লাস্ট অর্ডার ছিল।
এটার কোনো জবাব দেবেন না তুমি?
বোধহয় লাগবে না। আমার তো নতুন করে বলার কিছু নেই, তুমি তো ফ্যাক্ট দিয়েছো।
Would it be my lord's pleasure then to fix the contempt, my lord, for hearing of any day?
Let
My lord,
me
if
make
my
the
lord-
submission.
The question is,
Huh.
you have taken an exception to the
Exception.
report.
Yes, we
Exception.
have.
Your lordship will consider
By the
because
Yes,
contemner responded.
yes,
Yes.
yes. Because my case was very simple. After the division bench order,
Let the learned advocate for the contemner deal with that exception
hearing date
on the next.
very well, I don't mind that, and lordship fixes the contempt petition for final hearing.
Yes, record.
your lordship will also record my submission because at page number 31, which I was drawing your lordship's attention to, which is forming part of the EC application. In the EC, they have filed an application. Kindly see prayer B of the master summons there.
এই এটা দিন মাস্টার সামন
একটু দিন না জজ সাহেবকে।
মাস্টার
এই তো
সামনটা দিন GA4
GA4 এর master summonsটা দিন। It's forming part of the opposition. My lord, the opposition which has been filed by my learned friend, it is forming part of that.
অপোজিশনটা দিন না জজ সাহেবকে আজকে যেটা দিলাম।
আজকে যেটা দিলেন GA4 আলাদা আছে এর ভেতরে ওই opposition
The exception affidavit,
GA4 was
No.
disposed.
the affidavit which I filed today, taking my lord affidavit to her exception,
Exception.
that contains my
Contains
lord
the
the master
GA.
summons in GA4.
Affidavit.
Affidavit.
Yes, your lordships.
Yes, which page?
Page number
31, my
31.
lord, is what she is referring to.
This is an application which is filed before the coordinate bench by my learned friend. Kindly see prayer B. Alternatively, a fit and proper person be appointed as special referee to verify the legal correctness of the computation and calculation of the decretal dues payable by the judgment debtor in terms of the award dated so and so, as modified, passed by the learned additional special land acquisition judge at Alipur, South 24 Parganas, and further modified by a judgment and decree dated 2nd December 2024. And prayer A is an order be passed declaring that a sum of rupees such and such is due and payable to each decree holder as on 31st of March 2026. Now, pausing here for a moment, my lord, the money which Reserve Bank of India is required to disburse as per the case made out by my learned friend, I believe is the same money as he has sought for in prayer A. If that be the position, then how come, may I put the question to myself, then on what basis will a contempt lie? Because he is also seeking a declaration before that forum that this is the money which is due and payable to each decree holder as on 31st of March 2026.
My lord, it is better, my lord, if my learned friend's client puts it, my lord, on affidavit, dealing with my affidavit, so
My
that
lord
we
records
understand
my
what
oral
is.
submission. My lord records my oral submission, then passes whatever order.
Lordship, I appear for the state. Lordship, I have to apprise your lordship. First of all, as I have been made to understand, state of West Bengal is not a party to this contempt proceeding.
Okay, copy.
Now, lordship, the award.
See, state of West Bengal, you see, at present has no role. Only if pursuant to this order, there are any settlement between the parties, then that can.
No, lordship. I'll tell your lordship what the situation is.
You see, now you see, main order cannot be varied. Only this court has to dispose this matter.
No, lordship. The calculation is under challenge. We have preferred an application before the Honorable Justice Ananya Bandyopadhyay, wherein her lordship is possibly has appointed a
they have also
will appoint a valuer for the purpose of valuation, lordship.
There is no such order yet, my lord, passed.
This is the relief it has
Preparing the decree holder number 3, the same will supporting.
So my only prayer is your lordship
And learned advocate for the
alleged contemptor numbers 1, 2, and 3.
respondents are present. An exception is taken to the report filed by the contender respondents. Copy served. Let any affidavit be filed with regard to the exception submitted by the petitioners. Stop. Mr. Bagh also appears for one of the decree holder, although not a petitioner in this contempt application. And yes, your name you just
Mine, Akash Munshi, Mr. Akash Munshi.
Akash Munshi also submits that he is appearing for state of West Bengal and certain calculations is required to be made. Thus, this matter stands adjourned till
My lord, week starting 17th August, if that is, my lord, possible.
14/8. Okay.
My lord, we kindly not make it returnable on 14th date. I have some personal difficulty.
17th or 18th?
No, and Friday it is.
Friday.
Oh, Friday then 20.
Okay, 21/8/2026.
Great.
20. 21 হবে না 20 my lord, in that case makes it kindly 28, my lord, because 21 I am not in town, my lord.
28 there is some uncertainty.
Or 7th of August, my lord, 7th of August.
I have to file the
Yes, 21st
reply also because
very well,
14th
21st
also
lordship keeps it 21st take
Great.
আমি থাকবো আমার সকালবেলা অসুবিধা নেই আমি করে দেবো
Lordship, I appear for the plaintiff. Lordship, the GA3 has been disposed of. Kindly fix this for matter for hearing, Lordship.
Question is, you are appearing for the plaintiffs. Evidences of the parties are complete.
No, evidence has not been complete.
It has to be fixed for evidence.
I prefer evidence.
So all the judges' brief of documents all are filed.
We have to file it, Lordship.
Learned advocates for the plaintiff is present. Let necessary steps be taken by the learned advocate for the plaintiff regarding filing of judges' brief of documents. Let this matter appear on 21/8/2026.
Much obliged, Lordship.
So how is this matter appearing before this court?
This is
matter is not part heard.
No, this is just modification of your lordship's earlier.
So it can be before the regular bench. So why this bench?
It is
Whatever
actually,
it is, you see.
I'll
It is
tell
not
you.
a review application.
May not be, my lord, but kindly have a look at the prayer, my lord. I don't think, my lord, we can go elsewhere because this is a very short issue. My lord, kindly have a look at the notice of motion. Only, my lord, the sale has been confirmed, but the one of the joint receiver has died. So conveyance cannot be executed. Your lordship has to, my lord, give an incidental direction in terms of your lordship's last order. Either the
What prayer you have made?
kindly have a look at my lord. My lord, order dated such and such be modified by directing the surviving receiver to execute and present for registration the deed. I have already paid. Entire amount has been paid.
One of the receiver is still alive.
Yes, one of the receiver. He can just execute and sign.
Other receiver, my lord, died on 17th of June 2026.
That is why we have come up now.
So both the receivers are to sign.
Or since there was joint receivers, originally both had to sign. Now one have died. So, my lord, we can't, my deed cannot be done. I am already out of pocket. I am only just saying, my lord, this is not concerned with the estate at all. So let the sole surviving receiver sign and execute the deed. Unless that authority is given by your lordship, he cannot. That is the problem.
My lord, I am appearing for some of the co-sharers. My humble prayer is let the process of appointing the second receiver is on the way. So let the
Second receiver is appointed.
No, it's
The
not in the
application is
process.
pending.
No.
Then, my lord, how will we in the process? And I will be stuck, my lord, kindly see. My money is already with them.
Yet been filed, my lord. I do not know.
So, my lord, kindly see, these are
By which fund this receiver is being paid? These joint receivers? From which fund?
But I don't know, my lord. I am.
Which fund?
I'm an outsider.
From the income of property.
Estate.
Of the, my lord, estate. On this one.
But I will be most respectfully submitting, my lord, do not kindly put me into their family dispute. Now, my lord, an application will be filed by one co-sharer for appointment. it will be opposed by the other co-sharers, not this person, that person. So I will be stuck. That is why I am saying, my lord, either your lordship directs the sole surviving receiver or the registrar original side be directed to execute and sign. Whatever, because I can't get a title, I have paid. Or any person may be appointed as special officer, any advocate may be a special officer for the purpose of signing. So the problem can be solved. Because the appointment of a party receiver is not an easy task in this kind of a litigation. So I
record an order.
My lord, another submission is, well, in the order dated 2nd May 2025, passed by your lordship. My lord, it is written that let there be an order in terms of paying of the notice of motion upon receipt of the entire consideration money of 75,000.
yes, well, I am obliged. But he has pointed out I am
per
kata.
Otherwise, 100
Yes.
for 75,000. That is
So that is clarified.
no, my lord.
No, kindly make it clear. Make it clear also. Kindly make it clear.
Clarified, my lord.
Per kata.
Kindly come to page 32.
Page?
No, last page.
Last ভুল থেকে গেছে।
And also in the first part of the order is
Clarification can be done. Okay, there is no difficulty.
Page 34, your lordship, kindly come to page 34.
না এখানে করা আছে গো।
The entire
Upon receipt of
consideration
entire
money,
consideration 77 lakh
25,000 open আছে।
কোথায় আছে?
25 order যেটা আছে।
Okay, let that be upon receipt of entire consideration money of rupees 75,000.
Subsequent order.
The per kata is missing, my lord.
So 75,000 per kata.
It should be per kata.
তুমি কোথায় দেখাচ্ছ?
That has been.
সেটা লেখা আছে স্যার 75,000 only per কাঠা লেখা আছে
Page?
32.
Of the petition, it is mentioned কিন্তু দেখো।
এখানে here it is clear.
Here it is clear. I don't know which.
I don't know. There is a
75,000 per kata.
whether it was
That was earlier. That was earlier.
Rectified by your lordship. Subsequent order.
Oh, I think then leave it when it is already rectified.
Okay. Upon receipt of the entire consideration
Yes, that is
money
perfect. Well,
of rupees 77 lakh.
yes,
20,
perfect.
77 lakh 25,000.
It is perfect. Perfect.
handed over this order. That's why.
Yeah. Okay. Yes. Learned advocates for the parties are present.
Advocate on record of the joint receiver can be appointed special officer for.
Learned advocates for the parties are present. Learned advocate representing one of the joint receiver is also present in court.
Yes.
The application being 290 of 2026 is taken up for consideration. It is the contention of the applicant, who is the purchaser of the suit property, that one of the joint receiver died pursuant to order dated, that is order dated 2nd May 2025. Thus, either the present receiver be permitted to execute the conveyance deed, or the Register High Court Calcutta be directed to be requested to do so, or a special officer may be appointed. In the facts and circumstances, as the main matter is not in dispute, and it is only the conveyance deed which is to be executed, this court appoints Dash as the learned special officer to execute the deed of conveyance in terms of order dated 2nd May 2025 upon necessary compliance of all the terms as directed in the said order. Upon necessary execution of the sale deed, the learned special officer shall submit before a report before the bench having determination in the matter.
Let it be before your lordship in terms of this, because otherwise it will.
Submit a report before this court on 14/8/2026,
within which time the convent shall be executed.
within which the conveyance shall be executed, and the remuneration from the fund.
Yes.
From the fund.
The affidavit of service. No, affidavit
of service file became to the record.
করিয়ে দিলে তুমি।
ভোটের দিন থাকবে ওখানে।
Lordship, kindly make it clear the remuneration of the special officer be paid from the fund.
Yes, kindly provide.
That I shall clarify. আচ্ছা ওখানে লিখে নেবেন তো the remuneration of the special officer should be paid from the joint fund
Fund of the state.
of the state.
ওইটা দাও, ওই পুরোনো অর্ডারটা দাও যেটা বার করলাম, বার করে দিলাম, তুমি আবার দিয়ে দিলে।
Well, I am for the defendant.
Lordship recollects, my lord, that stamp duty issue, but finally done, my lord. Only one thing what had happened.
Yes, Lordship, I am for the collector. It's been
All done.
Directed an affidavit to be.
Yes, my lord, the affidavit
My
was
lord, the
required to be filed by my client.
Has been served yesterday. Today, my solicitor could Xerox and give me a copy. Lordship, give me some time to consider that and come back.
No, my lord, I am not asking anything to be done by the defendant. May I just indicate one thing, my lord?
But
If
now
stamp duty SS.
Now you are to the residuary portion. You have
Yes,
that link.
correct.
The only thing was this stamp duty was not paid. So that is done.
Yes.
So you come.
Well, I don't know whether that is done. So I want to see the affidavit.
The state is the competent person to say that.
Yes, Lordship,
Well,
it's been paid. It's
not
been paid.
necessarily.
Has I been
Not necessarily.
My lord, may I just
let us
complete
consider
one
and come
sentence,
back.
my lord?
The state and the this court.
Agreed, my lord, but we have something to say. Let us consider the affidavit and come back. And my lord's order may be directly to be uploaded.
Advocate for
My lord, may I just say this, my lord? My lord, you are pursuant to your lordship repeated directions. Finally, it has been done. Stamp duty SS, stamp duty paid. Now, my lord, what has happened now is the original is required to be sent by the department, my lord, to the collector's office so that the endorsement of stamp duty can be made on the document. So, my lord, kindly direct that certification is required to be done. My lord, kindly direct the department to send the original MOU on the basis for the purpose of certification to the collector. Yes. Impounded, filed in court, and impounded pursuant to your lordship's order of 18th June 2025. This is the order. So based on this, the original has to be sent to the collector's office for certification of the stamp duty which has been finally paid.
Exhibit Q.
This was exhibit Q in the suit. And in the meantime, the defendant can come back with whatever they have to say on my affidavit.
The learned advocates for the parties are present. Learned advocate representing state of West Bengal is also present. It is submitted by the learned advocate for state of West Bengal that the stamp duty which was assessed by the collector is already paid. As the learned senior counsel appearing for the defendant take time to go through the affidavit regarding payment of stamp duties. The matter stands adjourned till 14/8/2026. Stop. In the meantime, the MOU be sent by the registered original side to the collector of stamp duty, Register of Assurance, Kolkata, for making necessary endorsement
Certification.
and necessary endorsement on the same and issuance certificate in this regard. Learned advocate appearing for state of West Bengal is requested to see that the matter is done expeditiously.
Grateful.
Lordship, give me some time to consider.
Yes, you
Yes.
given you for you have granted time. Acha, are you agreeable on anyway? Acha, কবে দিলাম ম্যাটারটা?
Well, yes, last day's order and today's order, let it be uploaded, my lord, as early as possible. I think last day's order is not yet been uploaded.
এটা কি ইয়ে করতে হবে তাড়াতাড়ি পাঠিয়ে দেবে।
কবে রাখবো বলো?
আচ্ছা এই এক মিনিট
17 July order is there, sir.
আজকে যদি কোনো কারণে না হয় তাহলে একদম প্রথমে
17 July order
সপ্তাহে কি হয়েছে আগে
এই তো আছে।
কবে এই করে গেছি কবে আপলোড হলো? এই
17 আগে থেকেই ছিল আপনার।
গতকাল
Lordship is to make it returnable on the
14th.
Oh, 14th to be my lord, instead of 14, my lord, my junior is not here. Could it be on The week thereafter, 21st.
14 is 21st.
Grateful. Obliged.
Difficulty always accommodated.
Yes. I wanted to keep it on this thing, 1st of August, because the much matters will not be there, so that both of you can argue.
Yes.
But
1st of August, Saturday.
Sought for.
Affidavit of compliance.
And Lordship, I find there are affidavit to be filed on the returnable date. Where is that affidavit?
Yes, affidavit.
Today filed.
Okay.
We filed today,
the
but
affidavit
kindly
filed
take it on record.
we kept with the record.
And a copy be given.
No, you have been
Yes,
given copy.
sir. Otai.
Wait, okay.
Copy served. Obliged.
Obliged, my lord, obliged.
ওটাকে obliged বলে?
আমি অনিরুদ্ধ মিত্র।
Oh.
But this matter, my lord, I'll take the point of maintainability of the application.
Lordship, I'm appearing for the petitioner's plaintiffs.
My lord,
May I
no, my lord,
may I
before-
submit first, Lordship? This is my
I'm
application.
raising a preliminary objection. Your lordship will hear a.
You have filed your affidavit also.
Yes,
There you have taken the point.
yes.
So let us go through
Lordship,
the
may I
affidavit.
file?
Yes, my lord, but let.
Lordship, may I file the affidavit in reply? And Lordship will kindly note that they have, my learned senior friend is appearing.
We conclude the matter today. No more further.
I will submit only.
Okay, let him submit, but.
Yes.
May I say this?
Lordship will kindly allow
permit
me
me
to
one
do
minute.
some.
Yes.
1 second. This is a matter which your lordship has heard on merits. Notes of argument has been filed by both parties. Your lordship has delivered a judgment.
See, just a few days ago, the Honorable Supreme Court has delivered, the Honorable Chief Justice sitting with Justice Bakshi has passed an order that an order which is not signed can be modified or rectified.
This
Have
is
you
delivered.
No, question is order which is not signed, maybe very subsequent stage. Have you obtained a copy of that order? So if you can obtain a copy of that order, I can consider that. It's a recent, just
Yes, I've seen that. But how will it, may I greatest of respect, how will that help us?
That is the case of your learned friend. Yes.
I will make my submissions. I will.
You want the oral or the order which was unsigned, that order to be revised.
Yes, may I just.
That is his case.
Because they had obtained a recalling on the basis of misleading submissions. Lordship will kindly allow me to submit. Because
Kindly see, but I do not know how as a lawyer we can come with an application like this.
that Lordship will
What
consider.
he is saying, he has mentioned there is an order which is recalled on mentioning matter has been
Mentioning without notice.
না আপনি বলুন তাহলে আমি চলে যাচ্ছি এইভাবে বলা যায় না মানে kindly see this type of a case Lord. He has mentioned the matter has been mentioned, matter brought on list has to be mentioned. It does not end there. Matter has been then fixed for final hearing. Matter has been argued at length by the parties. Notes of argument has been filed.
These are dealt with you. These are contended by you in your affidavit in opposition.
And our material submission was not recorded.
Only thing is this, you see, whatever you have stated with regard to maintainability and other facts, definitely I shall consider. What I was asking you, can you obtain that
Yes,
decision?
I will.
Then the purpose is served.
I will. But question is whether this kind of an application should be dealt with in a manner that the person is not encouraged to file this kind of an application.
Anyway, let him complete his
Lordship.
submissions. You bring that.
If a maintainability point is raised, well, that maintainability point
That is the clear question. That is the order as per of the Supreme Court.
I will answer on that. I will
Yes,
satisfy
yes,
your
yes.
Lordship.
then Malad, let him if your lordship Malad, I was submitting this. There is no question of going into the merits of this matter. First, your lordship will decide at all whether the application is maintainable or not.
Very well. Let him justify that.
Lordship.
Yes.
Let
me indicate.
No. He is the applicant. Let him justify.
Lordship.
Okay. How it is maintainable and what are his reliefs.
Lordship.
But
Yes, please.
if I indicate the ground, it will be easier for him to.
Very well.
Yes, that is what I was saying, Malad. If
Lordship will kindly allow me to submit first.
No,
then he can
maintainability, you
submit.
answered the maintainability point. Your lordship will kindly see first, Malad, prayer A. Prayer A at page 15. My learned friend can argue for days together.
No. I will conclude today.
Maintainability point. Order dated 13th August 2025. Lordship has got it?
Yes.
Passed in the morning. allowing praise A to G of master summons filed in such and such be restored. After recalling and or modifying the order dated 13th August 2025 passed by his lordship at about 4:15 p.m. on mentioning in the absence of the petitioner as well as the order dated 4th September. First of all, there is no order in the morning.
The order passed on 13th of August. Lordship.
My lord. Then, my lord, what he is ultimately asking for recalling an order of 13th August at 4:15 p.m. That order is not in subsistence because that has merged with 4th September. So he is asking for actually recalling of 4th September. There is no provision for recalling of a 4th September order, an order which is passed in the presence of the party, and upon hearing him, the court has become functus officio, application is disposed of, court does not retain the power to recall that order of 4th September. 13th August he cannot ask because 13th August has merged with 4th September. 13th August so-called order which is saying at 4:15 p.m. So his prayer of recalling 13th August does not arise. It has merged with 4th September. 4th September recalling, the court does not retain the power to recall because an order which has been passed in the presence of the parties upon hearing them cannot be recalled by the court. The only provision is a review and an appeal. So on these two grounds, I say this application is not maintainable. If he is aggrieved by the 4th September order, he has to go up in appeal. He has no other remedy in this determination. This GA number 31 is not maintainable because it is contrary to the provisions of law.
Very well. Let him
These are my submissions
Lordship.
on maintainability.
Lordship, on 13th of August 2025, I had moved an application for substitution. And after hearing the matter, the Honorable Court was pleased to pass an order allowing the application. Thereafter, again, the Honorable Court was pleased to recall that order upon mentioning by the learned senior counsel for the dependent 18B, C, D, and 17A, mentioning without notice. And Lordship mentioning upon misleading submissions. Their contention was that they are not aware of the matter. No copy of the application or master summons had been served upon them, and that the suit is disposed of. Now, Lordship, the matter had been fixed by this Honorable Court on 2nd of August 2025 to appear on 13th of August 2025. So they were very well aware about the proceedings. They could not have contended that they were not aware. I had duly served a copy of the application and master summons upon the learned advocate and record. It was duly delivered and accepted. So it becomes binding upon them. If their learned advocate and record chose not to communicate to the client, the onus lies upon them, not on me. Their personal inconvenience cannot be a ground for recalling. Now, thereafter, Lordship, on 20th of August, I prayed before your Lordship to kindly direct to have the order passed in the morning of 13th of August to be uploaded in the server. Since the order passed at the time of rising of the Honor Court stated that the order passed in the morning stood recalled. However, it could not be uploaded since it was not signed.
Okay, where is the order dated
Lordship.
7th August?
Lordship, it is there in my supplementary
7th
affidavit.
August.
Yes, your Lordship.
Supplementary affidavit.
Supplementary affidavit, Lordship. Just a moment.
ডেটটা বলো পুরো supplementary affidavit.
August. Lordship will kindly take page 24 of my first supplementary affidavit. It's a thin bunch. Huh? কোথায়? Lordship, it's the thinner bunch. I had submitted পাতলাটা হবে। 6th of August 2025. Dated. Page 24, Lordship. Page 24, your Lordship.
This is a supplementary affidavit.
Supplementary affidavit. Order dated 27th.
This GA 31. What is this copy for?
No, Lordship, it's a thinner bunch. I had submitted 2 supplementary affidavits. This is the first one. Lordship is seeing the second supplementary affidavit.
Yes.
Date of affidavit.
6th August.
Yes.
27th August.
27th August is the order, Lordship.
Which page? 27th August? Yes.
Lordship is page 24.
Yes, 27th August.
Yes. Thereafter, Lordship, the matter appeared again on 27th of August. Now, on 27th of August, my learned senior had made substantial submissions before this honorable court with regard to the proceedings before a coordinate bench. A similar application had been allowed by a coordinate bench. An application for substitution had been allowed. Now, Lordship, our material submission at that point of time was not recorded and does not find any place in the order passed on 4th of September 2025. Our material submission at that point of time was that once a coordinate bench has allowed an application for substitution, it is not open for another coordinate bench to go into the question of whether the suit is disposed of or not. That would be akin to sitting in appeal over the decision of the other coordinate bench. And Your Lordship, with the greatest of respect, while that order is subsisting, another coordinate bench cannot arrive at a finding that the suit is disposed of. Lordship kindly considers and records this submission of mine. Now, thereafter, Lordship kindly comes to the order passed on 4th of September 2025. Just a minute. Lordship, it is on page 50 of my GA. GA 31, Lordship.
Yes.
Yes. The order starts on page 50. Lordship kindly comes to the operative part on page 56.
Yes.
Lordship kindly takes the fourth para. Although appeal being 222 of 2014 was disposed in the year 2014 and the execution of decree carried out in the year 2017, but till date no appropriate application is made in terms of liberty granted by the appeal court to justify that the suit is alive in respect of each of the properties mentioned in the schedules F, G and H of the plaint. Thus, at present, there is no dispute pending before this court to be adjudicated. In the absence of pendency of any dispute or application, there is no scope to entertain any application for substitution. Thus, this application for substitution being GA 29 of 2025 is dismissed at this stage in terms of the above observation. Now, I am grateful to my Lordship, Your Lordship. This Honorable Court has not arrived at a finding, or rather I should say express finding, that the suit is disposed of. The order says that since I have not filed an appropriate application till date, hence it cannot be justified that the suit is alive. Lordship, in my humble submission, I was not required to file any appropriate application. Lordship, the ground on which my application stood dismissed, this question or this issue was never raised during the proceedings. If that question or issue was raised, Lordship, I would have satisfied Your Lordship. I would have made my submission on the facts. Now, Lordship, I say that I had no onus of filing any evidence. If I take...
What prevented you to go for appeal against this order?
Lordship...
It's an appealable order.
Lordship...
Your matter is dismissed. What you see? You want a review of this order. Only review can be obtained only when there is an error apparent on the face of the
Lordship, my material submission...
See, the ground of appeal was much more.
Lordship,
the vast scope in appeal. You could have gone for appeal.
Lordship, I am not aggrieved.
In review, there is very little scope. Anyway, you submit.
Lordship, yes, Lordship. I am saying that yes. Just a minute, Your Lordship. Kindly allow me a moment. Yes, Lordship, I am saying that I have no onus of giving any evidence. Now, if I take Your Lordship a little back to the preliminary decree, in the order passing the preliminary decree, the Honorable Court had directed the Joint Commissioners to inquire whether any parties raised any disputes with regard to claim for greater share. If any party raised any dispute with regard to claim for greater share, then to take evidence, else to take steps for partition. Now, Lordship, I am not claiming any share greater than that stated in the plaint. It is my plaint. I am only claiming the share as stated in the plaint. So I have no onus of filing any evidence. Now, Lordship, I will come to it later. Now, Lordship will kindly take the order past the Honorable Division Bench, presided over by Honorable Justice Munjula Chellur, as his Lordship then was.
Page 72. Page 72.
Lordship will kindly take page 40 of my application. It's the operative part of that judgment.
Page 40.
Page 40, Lordship.
Yes.
Yes. Lordship, now, Lordship, this judgment, may I submit that this judgment has not been appealed against. It is not overruled, not set aside, and remains subsisting and is binding upon all the parties, all the subordinate courts, and your Lordship, with the greatest of respect, upon this honorable court as well. Lordship, may I place the third para? As stated above, the court can proceed to decide finally what is the respective share of each of the parties to the suit.
So you don't have any grievance with regard to chair. At present, you don't have any grievance with regard to
No,
chair.
Lordship, the shares are pending to be decided.
Okay. Yes, my lord is
So,
saying
yes, Lordship, I'll submit.
regarding C.
Yes.
We want the respective CRs, admitted CRs.
As stated above, the court can proceed to decide finally what is the respective share of each of the parties to the suit, so far as the residuary properties and business, depending upon the evidence recorded by the Commissioner. Lordship, I pause here. I say that this is not a mere observation. This is a direction upon the learned court below. And with this direction, the decree still remains kept in abeyance. And as long as the decree remains kept in abeyance, the question of reviving the decree cannot and does not arise. The question of execution also does not arise. Now, the executing court has proceeded with execution, but it did not have the authority to do so.
So did you challenge that or execute order?
Lordship, I had challenged, but I
Where is
did.
that order?
Lordship, I do not have that order right now.
Why have you not annexed that order?
I will submit before Lordship. Lordship, I did not
The
succeed.
question is you are challenging the jurisdiction of executing court. Okay. So have you preferred any appeal?
Lord, I am not seeking adjudication on that issue from your Lordship.
The question is, you see, that is all inconsistent things.
No, Lordship, it is not inconsistent. Lordship, I am trying to make my submit.
Challenge something, you have to show that the order is set aside and it does not apply to the facts of the proceedings. Then
Lordship, I am saying that pursuant to this judgment, where the Honorable Division Bench has directed that court can proceed to decide the shares. So, Lordship, the suit remains pending. The shares cannot be decided unless the suit remains pending. If the suit is disposed of, the shares cannot be decided. That is the point I'm trying to make before your Lordship. Now, Lordship, I come to the next part. It is also open to the plaintiffs to seek relief of permitting them to lead evidence if they have not done so. Now, Lordship, as I submitted earlier,
So a rehearing is going on of the application. Which
Lordship
your
will
Lordship has
kindly allow me to
disposed of
make it. Lordship will kindly allow me to make my
many
submission.
submissions were not recorded in the order.
Yes, my material submission was not recorded.
This is not that application.
So many submissions, if it had been recorded, the order would have been.
Yes, your Lordship.
This is not an application for that. He cannot file a recalling application on
That Lordship will decide.
He has to choose his remedy.
That Lordship will decide.
Let him come.
The question is the order, whether the order passed by the executing court that the suit is disposed of, was that challenged?
Yes.
So what is the fate of that proceeding?
Recorded everything, but today I am not.
According to your learned friend, the order was challenged but not decided.
Lordship will kindly see. Lordship, I am showing a
Order of the court saying execution is complete. Satisfaction of execution is recorded. After that, your Lordship will again hear the suit.
execution. Yes.
Again, I say, my lord, your Lordship will first decide my preliminary objection. Today, if he says that his submission is not recorded, law gives him a procedure for that. He cannot just come up with any application and say, recall an interim.
Anyway, you complete.
Lordship will kindly allow. I'm grateful, my Lord. Now, Lordship, I am trying to submit before your Lordship that execution has been done only on a part of the properties, not all. Your Lordship can see here, court can proceed to decide finally what is the respective share of each of the parties to the suit so far as the residuary properties and business. So this part remains to be adjudicated upon. The shares have to be decided. This is a partition suit. Now, Lordship, I come to the next part. It is also open to the plaintiffs to seek relief of permitting them to lead evidence if they have not done so. Lordship, as I submitted earlier before your Lordship, I had no onus of giving any evidence. Out of abundant precaution, I've given evidence. And if required to take steps, Lordship, I will take steps only after substitution is allowed. I cannot take any steps prior to that. And if I have to give it evidence, I can only give evidence where there is a suit pending. And now, Lordship, the suit is not, the substitution was not pending since 2025. Lordship, the substitution was pending since 2015. May I kindly place an order before your Lordship of Honorable Justice Shomen Shen. Lordship will kindly take.
Is it a part of the record?
Lordship, it is it is there in my affidavit in reply, Lordship.
Affidavit in reply.
Lordship. Lordship, this is the dated 8th of April 2026. Lordship will kindly take page 12.
No. Did you annex this order in your application, earlier application? Or affidavit in reply when the
Yes,
which you are seeking the calling was.
Yes, Lordship. In this affidavit in reply, I have annexed it. Yes, Lordship, it was there. Yes. Lordship will kindly take page 12.
Previous matter, when the previous application was maybe in your application you did not file, but after the opposition was filed, did you file this in your reply?
Yes, it is there in my affidavit in reply.
No, not this reply, the earlier reply.
Yes, it is there in my earlier reply.
Earlier reply, it was there.
How can it be?
GA29. Lordship is referring to the previous application.
Yes. Because on your substitution application, your learned friend filed an application.
Lordship.
Okay. To that you filed reply.
Lordship.
Showing the maintainability or whatever it is. In that, did you rely upon the order?
Lordship.
The single bench.
I have filed it in this affidavit in reply.
But you are bringing in new documents. Okay, how can I go through this?
But
if
Lordship,
there is any error apparent on the face of the record, then the court can rectify it or modify it, whatever it is.
Lordship, this is
so if you can show any error apparent on the face of the record on the earlier order, then there is a scope. Otherwise, there is no scope.
Lordship, this is already part of the records, Lordship.
No question. Whether it was a part of your application.
Lordship, but Lordship, the point that I'm trying to submit before your Lordship is that substitution was already pending since 2015. And there was a direction upon them, upon the defendant 18 series by the Honorable Court to file substitution in 2015.
Thereafter, there are certain developments.
Lordship, I will submit. Now, Lordship, they chose not to file any application for substitution. I attempted to file an application. The same was returned back. Thereafter, I could not take any steps. Now, in the year 2022, the matter came up suo motu before His Lordship, Honorable Justice Sugata Majumdar, not at my instance, suo motu. I prayed for leave to file an application for substitution. Leave was granted. The matter was taken up. Application was moved. Application was allowed. Steps were taken by the department. Plaint was amended. And thereafter, I submitted before His Lordship that pursuant to a judgment of the Honorable Division Bench, the shares of each of the parties with regard to residual properties was required to be determined. And His Lordship had kept the matter pending for hearing. However, since records were not available, the matter could not be taken up. I submitted a copy of the plaint. Again, that was misplaced. So eventually, His Lordship could not take up the matter. Now, thereafter, I could complete the re-verification of the plaint only in August 2025.
Anyway,
Lordship.
These were part of your earlier application. Now, you tell me why this order has to be recalled.
Lordship, it is because they had...
Confine yourself to that.
Lordship, I say that this application is maintainable because your Lordship had rightly allowed the application by passing the order in the morning. At the time of rising of this Honorable Court, they obtained a recalling order based on misleading submissions.
Yes.
Your Lordship has ample powers to recall an order.
Very well.
Lordship. Yes, Lordship. And thereafter, Lordship, they had made those misleading submissions that they were not aware of proceedings. I have shown to your Lordship they were aware. They submitted that no copy of the application or master summons had been served upon them. I have shown to your Lordship that it was served upon them. And their contention that the suit is disposed of, I have shown to your Lordship there is a subsisting judgment of the Honorable Division Bench wherein shares of residue properties.
That was referred in the earlier order,
Referred.
earlier matter also.
Yes.
The division bench judgment.
Yes,
decided
it was
by the
referred.
Chief Justice, that was referred.
It was referred, but
it was a matter of, it is a part of the petition.
Lordship, but the question they raised was not placed before us on the previous proceedings, whereas we could not submit before your Lordship that since we have not filed an appropriate application. Lordship, my humble submission is that we were not required to file an appropriate application because I had no onus for filing an application.
To that portion you want modified, that you are not required to file application. Only that portion you want
Then-
modification.
Then Lordship will kindly allow the substitution because
Question is, you want that you are not required to file any application. Okay.
yes, because I have no onus.
That application.
Yeah. And Lordship,
Because if you want a modification of that portion of the order, that you are not required to file application.
I have not required. And Lordship kindly notes that after the substitution application has been allowed by a coordinate bench, it's my humble submission that another coordinate bench cannot raise that question.
That is the
Cannot.
question of
Lordship.
once a substitution application is decided by a coordinate bench, the another coordinate bench
Cannot entertain. This is my humble submission, your Lordship. Yes. And yes, Lordship, this is my.
This is one thing. The other,
Yes.
the order which was passed in the morning, that we recalled.
That we recalled.
And the question is, you are not required to file any.
I'm not required to file any. I have no onus of filing any application. And Lordship, just one more thing, Lordship. There are certain errors which had inadvertently crept into the order passed on 4th of September.
If some errors are there,
Yeah.
that can be rectified.
Lordship.
Okay. What are the errors?
Yes, Lordship, may I submit a copy?
Not a question of recalling. If there are errors,
Yes.
that can be rectified.
Yes. Wait a-
So if you want the entire order to be recalled, the question of rectifying the error does not arise. If you want the order to be kept intact, then the errors can be rectified.
Very well, Lordship. Very well. So, please submit. Lordship, we had submitted part evidence and the remaining part evidence was not given. Yes, this is my submission.
Yes, Mr. Sen.
And until and unless substitution is allowed, we cannot take any steps.
The shares of the party substituted applicant should be not affected. Unless we are substituted, we would be deprived of the shares.
Your Lordship has already recorded in detail the submission. Your Lordship kindly see what has happened, but they have not taken the report. Even the commissioner's report exception has been taken by them. That has been dismissed from there. My lord, they preferred an appeal. Appeal court has, my lord, accepted the commissioner's return.
So that was be done by the present applicants or their predecessors?
These applicants.
These applicants?
Yes.
Not the predecessors.
No. First, my lord, first set of applicant was one set of defendant. Then one set of defendants' rights stood completely closed. Then came the plaintiffs who were supporting those set of defendants. But I have shown your Lordship.
And this application for substitution is pending from 2015.
Well, kindly see how can it be pending? This is the fault, if I may permit it to be said, with the department. If a suit is decreed, there is an order of the execution court. I have shown the decree. What my learned friend is saying, no.
Question is, at
But
the time of passing the decree, if some of the parties are dead and a substitution application
There
is
is no
pending.
question of at the time of decree that anyone was dead. There was no substitution at that point of time. Decree was passed, decree was kept in abeyance for a short time to enable them to take exception to the commissioner's report. Decree was not set aside, kept in suspended animation. Commissioner's application filed, returned exception to the commissioner's application report. Single judge set aside, dismissed that application, affirmed the commissioner's return. Matter went up to the division bench. Division bench affirmed that order. Now, once division bench affirms this order, the earlier decree revived. If the earlier decree has revived, that decree has been put into execution. And what did the decree say? I have placed the decree. Decree said only part of the properties are admitted, joint family properties. Commissioner of partition will prepare a scheme of partition for those. Since they have not given evidence for the other part itself, they have not chosen to give evidence. So that has been set aside. Then they came up with an application for taking exception to the commissioner's return. So that opportunity also they got. Now, once their efforts to turn around or set aside the commissioner's return failed, that
all applications were disposed by the executing court.
yes, an execution, but your lordship has recorded everything. Your lordship will kindly come back to your lordship's order, my lord. Kindly come to page 50 where your lordship's order starts. But I am
50.
yes, well, I'm not supposed to make my submission on the merits because he did not answer my maintainability point at all.
I've answered.
Yes, 50.
At page 51. Kindly see your lordship's observation at page 52. Point urged before me on behalf of the plaintiff, final decree dispose of the suit for partition partially did not appear to be taken before the appeal court by the plaintiffs who were the appellants there. Parties were bound by final decree. Your lordship is recording that. And the judgment of the division bench dated 5th September 2012. In such view, the contention on behalf of the plaintiffs in that regard could not be accepted.
This view had been taken to be erroneous. The Honorable Division Bench had held this to be erroneous.
Recall this view. After hearing, an appeal preferred against the order dated by order that the Honorable Division Bench observed. Learned advocate also submits, this is their submission. An argument is advanced by the petitioner suit is still alive. Executing court does not have the power to proceed with this court is of the view that at the very outset it is remembered the learned coordinated way of hearing the parties observe that court can proceed with execution. Such issue cannot be reopened. It will be your lordship's finding, as this will amount to sitting in appeal over the other coordinate bench, which is not permissible in law. However, the learned advocate for the petitioner to justify suit is necessary to quote the relevant observation. Your lordship has quoted that observation. Kindly see, thus it will appear that although appeal was dismissed, but liberty was granted to the plaintiff to seek relief of permitting them to lead evidence if they have not done so. Although leave was granted, plaintiff chose not to file any prior to execution of the decree. Without necessary application, it cannot be held that this suit still survives. So this is a finding which has come.
And the finding was overruled by the Honorable Division Bench thereafter.
Just finding in this application. Now, therefore, my lord, every time I lose a matter, I will again come. If that is the law, my lord, then there will be never a finality to the litigation. But kindly see thereafter, page 55. Last line, learned coordinate bench while dealing with the execution case also observed as follows. Though Mr. Sen submits that while granting leave to the plaintiffs to take exception to the report of the division bench did not interfere with it, simply postpone it till the time the same has been adjourned. I find that certain observation recorded which according to the plaintiff must be set aside finally. This executing court not the party to agitate. Thus, it will appear from the observation the rights or dispute will decree included or to be decided not by MRT in a different forum. Till date, no appropriate application is made. But kindly consider the entire scheme which I had presented before your lordship. Certain properties were admitted to be joint, certain properties were disputed. Court passed a conditional decree saying that in respect of the joint properties, there will be a preliminary decree. And commissioner was also appointed at the same time to say, decide what is the share of the party, whether to give evidence, to take evidence and find out whether the other properties are separate properties or joint family properties. So the entire...
See, at the last also I have made it clear that that the court has not gone into the merits of the case or rights of the parties. I have not touched the rights of the parties. Simply seated on the grounds of this thing, maintainability. I did not go to the merits of the case also. Clarified that.
There cannot be any question of merits because my lord, the suit has been decreed.
Because I said
Suit has been decreed, your lordship will see.
Execution is satisfied. My lord, today I don't
It
have
can
the
only be on a
orders.
part.
Those I have filed a bunch of orders before your lordship.
in the opposition.
Yes, earlier matter, on which your lordship had said, recorded that execution court has recorded satisfaction of the decree.
But your lordship will see honorable division bench has kept the residual properties open to be determined.
An application, department registers that application and the suit revives. Is it permissible? And after 10 years, the client is served and the client has to come after the decree. He has got his share. The property has been partitioned. He is sitting there peacefully. And after 10 years, the notice goes to him. The suit is alive.
All these
Yes,
questions can now not be gone into because in 2023, a substitution application has been allowed by a coordinate bench.
That point I shall record.
Until and unless this type of application is dismissed with heavy costs, this will again come back.
And lordship, if lordship kindly allows me to apply briefly to what my learned senior friend has just said. So my lordship, my learned senior friend mentioned that the report of commissioner being confirmed by the honorable court. I agree to that. But your lordship will kindly see that when the honorable division bench.
Let him conclude.
Yes. Look, I have to show your lordship.
How the recalling application is maintained.
Absolutely.
There is a, what is the scope of recalling?
What is the scope of I am not going to make
Because this is not an appeal.
Not an appeal, not a review.
Yes.
Yes.
There is no scope of recalling if the person in the applicant has been harmed.
Yes. What are the things
Yes.
you have to add now?
Yes. Lordship, I'm saying that with regard to the return of the commissioner. Now the commissioner had closed my evidence. So the final decree had dismissed.
Merits.
I have to
answering the question.
The question is, what these points were considered in your earlier application upon hearing both of you.
Lordship.
So what is the error in that order for which you want rectification or recalling?
Error, Lordship, I am saying that my material submission was not recorded. That they had
your material submission was not recorded. That substitution application
had been allowed by a coordinate bench. Yes.
Which cannot be varied by this bench. Yes.
No, that application for recalling is pending.
No.
Yes.
Prior to that.
Yes.
While that remains subsisting, another coordinate bench cannot arrive at a finding.
The other point is this.
And they are saying that they were not aware of the proceedings. They had obtained that recalling order on the basis of misleading submission.
The other is this. When the earlier order of substitution was allowed by this bench, you want that order to be revived.
Lordship.
And this order dated 4/9/2025 to be recalled.
Lordship.
These are the two submissions.
Lordship. And we have given part evidence. We do not have onus of giving any evidence. If steps are required to be taken, I will take only after substitution is done. And substitution was already pending since 2015. This is not an issue which has come up in the year 2025. Lordship.
Yes, you want to add anything?
I want to add one of the substitution is necessary because we are the interested party. We have the share. Unless substitution allowed, we will get nothing.
Yes.
Decree.
Okay. Record an order. Learned advocates for the parties are present. Hard learned advocates on the application J31 of 2026. Hearing is concluded. Let this matter appear for orders on 21/8/2026.
21. I'm grateful, Your Lordship.
Substitution is necessary.
Item number 10, my lord. My lord, this is a Bata matter. My lordship wanted the.
Lordship, may I have one indulgence? Lordship, my written submissions may kindly be taken.
The written notes of arguments file be kept with the record.
I'm grateful.
If my lord sees my lord the last order, my lord, both parties wanted to sit for settlement, and they have. No, some other parties there for the plaintiff.
Repeated occasions, my lord, they are obtaining the adjournment.
But this person, I believe,
Indicate, my lord.
the learned counsel, my lord.
We have been writing
on record.
Even later.
I believe he is not authorized even to submit because he has no vokalatnama.
We have
My lord, may I submit something? May I submit something? My lord, talks
From
of
the Advocate on Records office.
my lord, talks of
So
settlement are going.
the talk of settlement is effectively going on, And now, my lord, is perhaps, my lord, at the, we are at the.
Intimate the offer. If
Sir,
they are not.
first show your locus before the
Yes,
court, then
yes.
submit.
My
No,
client is there.
Mr.
No
Chakraborty,
matter.
you see, Mr. Chakraborty is definitely engaged
No.
by the advocate.
My lord, we have never seen him.
Not appear.
Yes.
My lord, we have never, because the advocate on record is in front of your lordship. They say they have not engaged.
Now senior is here.
My lord,
Yes, submit.
my lord.
My lord, I don't know, my lord, because. But only thing, my lord, that the settlement is effectively going on, my lord.
So what do you want? Time?
My lord, 2 weeks
So
time
let
may be
us 2
given.
weeks time in the meantime be given.
We shall come with the.
Let them disclose their offer. Let them disclose their offer.
Learned advocates for
Only, my lord, they are lingering.
Yes, yes.
It is submitted.
My lord, only one thing, my lord. And my lord, we have also approached the commission, but the suit is undefended. If the settlement doesn't fructify, we have to hear, he made the hearing. But the commissioner says, my lord, if just mention it to the honorable court on the one line direction, we will give the record, the evidence, questions, everything.
Learned advocates. Learned advocates for the parties are present. It is submitted by the learned advocates.
The shortest possible date, maybe.
That the talks of settlements are going on.
After 7th, my lord.
But the learned advocates are requested to submit the necessary documents with regard to the settlement. Let this
It is not minuted, but both the sides were there. They were there, we were there.
matter
In the office of Victor Moses.
after 1 week.
Madam, no matter. I have some.
After one, otherwise it will not.
My lord, only one thing, I have some. My lord, allow me, for the first time, and he is submitting. At least he should.
No, you have not seen Mr. Chakraborty earlier
In this matter, not.
in this matter, but you have seen him.
But no order lordship will find in the, even in his name is appearing.
It is not a new
No,
case.
Mr. Chakraborty, man, how can I say that? But only one thing, man, I have some personal difficulty because I have the, I'm a little embarrassed to say, any day after 7th of August. Any day. And that I've told to my learned friend also.
Advocates for the parties are present. It is submitted by the learned advocates that talks of settlements are going on. In the facts and circumstances, matter stands.
Commissioner,
14/8/2026. Let relevant documents with regard to the settlement.
Yes.
On the next,
And the commissioner, for one line
on the
direction.
next day, I shall pass that.
Man, the commissioner person is already here. They are ready to give us the report. If the settlement doesn't fructify, but the commissioner had made the examination in chief by virtue of the order of the court. Now, my lord, the commission, we have asked for all the documents, depositions, copy of the depositions. That commissioner says, yes, I will give, just give up. Get it mentioned before the court.
File the report.
No, they have filed the report. They have filed the report.
Yes.
And when we have asked for the copy, they say, tell it to the honorable. His person is also there. Just to see.
Okay, but just it's not so urgent now.
No, my lord, because if the settlement fails, my lord, we have to get ready for hearing.
Thereafter, I shall direct.
Yes.
You have taken so much long time for settlement. Now you say saying that.
Very well, lordship, but
so long time you have obtained.
But otherwise, we will get the reports.
Yes, you are entitled to that. You'll get it.
My lord, may that be recorded. That on the next day it will be over.
The matter is already appearing as undefended.
If the matter is not settled, then that direction. will-
So, my lord, may that be recorded. When next day, sir, we can give a immediate recapitulation to your lordship on that. It will be lordship will consider it on the next day. The report of the commissioner.
Might be on the next day.
Yes, the report of the commissioner, lordship will consider on the next day. May that be.
Anyway, why you don't want the settlement to take place?
Yes, obviously. That's why, my lord, as your lordship, please.
Come on,
Lord, my lord is pleased to keep it on 14th August.
14th. If it is not settled, that report will be
No,
handed over to
definitely.
you.
No, my parties are very in a verge of settlement.
Record the report of the commissioner. We handed over to the parties on the next date fixed.
Report and depositions.
Reports, yes.
And
report
deposition.
And deposition.
Copy of deposition.
Shall be handed over to the parties on the next date fixed.
Deeply obliged,
Well, one thing, may I say, subject to what Mr. Ghosh says, there's one document that is the will of Manju Devi, Manmal Bhutodia. That is a 1999 will. By the dint of that will, their case is that Manju Devi acquired the 1,000 shares which are now in dispute. It is the plaintiff's document. Plaintiff nowhere has disclosed that will. We have already, my lord, applied to the department, my lord, the probate department, my lord, to obtain a copy of the probated will. In that event, my lord, it will take some time if
Question is, I am hearing order 7 rule 11 application.
How is
I am
this-
not, the court is now presently not concerned with
now
all this.
why I say
Let
this,
this this hearing be concluded.
why I say this, my lord.
Want adjournment, I'm adjourning the matter. But this not on the ground that until you obtain the document, I'll not hear this order 7 rule.
Lordship is hearing two applications simultaneously. One is the recalling application, my lord, and one is the order 7 rule 11 application.
Order 7 rule 11, you see, court has to confine with the court.
Absolutely. I'm not on that.
To recalling,
I am not on that.
hearing the record, I either have to allow or I have to reject.
Absolutely. So this is why I say this, my lord, on instruction, my lord, this is a relevant document because on the dint of this document, Manju Devi, but we will bring it to the record. Lordship will give us that, my lord. Absolutely not on that, but on the other application, Lordship can rely on that document.
Take that at the time of fixing the issue of maintainability.
Precisely, my lord. Lordship will give us that time, my lord.
Definitely.
Yes. Lordship will give us a time of 2 weeks, my lord. We will get it, my lord.
So as far as one more thing, my learned friends, if your lordship recalls, Mr. Bose has said that they have finished their submissions 5 times over. But only thing there was a recap because he was to inform your lordship about the law, what cases. Till now also, at least let them give me let me get ready because I have not seen any cases that were cited. I came late, but then now it appears no cases were cited and no law. So at least they should, even whichever date they keep.
Learned counsels for the parties are present on the prayer of learned advocate for the defendant. The matter stands adjourned.
Next week.
Next week হবে না, আসবে না।
ওইটা তো is not a relevant.
7. Yes, next week or 2 weeks.
2 weeks. 7th will be fine.
So accusation is that I am not taking steps in the suit. That's the only reason.
They are not. That is precisely the reason.
2026.
7th August. ঠিক আছে। Very good.
Grateful, my lord.
Yes, 11 and 12.
Great.